I expressly do not consent to this court's jurisdiction or do not...
Well, then you are not a named party, so if you're not consenting to this court's jurisdiction, sit down. You can go.
Oh, I see. So I need to...
I don't know what you need to do, but...
Oh, let me respond.
To what? You're not consenting to the jurisdiction of this court. Why am I hearing from you?
Recanting.
You're recanting what?
As stated.
Which part?
The part that, I lost my spot. Oh.
Well, no. It doesn't work that way.
Okay, I'm not understanding. I am nervous. Quite nervous.
This entitled Sovereign Citizen Squatter Karen is in court today over an alleged fraud case tied to a $1 million house she refuses to leave. The plaintiff's attorney breaks it down at the start of this hearing, and honestly, you'll want to pay attention because it shows exactly how ridiculous her scheme is. I mean, she's running the classic sovereign citizen playbook, spitting out nonsense about rights and ownership, but on paper, it's one of the messiest fraud cases you'll ever see. I mean, the confidence she has walking into this courtroom is honestly laughable compared to the reality of her situation here. What's crazy to me is squatters actually do get certain legal protections in some states, which is why people like her try to exploit loopholes. But this case is a little bit different. I mean, she's not just squatting. This is a high-level fraud dressed up with sovereign citizen word salad. Let me know what you guys think. Do squatters deserve rights? Or should the laws be changed so cases like this never get this far? Let's dive in and watch here.
Ian Redmond, B70599, on behalf of the plaintiff.
Your name, ma'am? Pardon?
Joshua Banks, occupant, Your Honor.
Okay. So you're not Miss Whitlow? So what is your position in this case?
If I may, Your Honor.
Okay, good. Go ahead.
Ms. Banks claims to be an occupant of the property. She filed a bankruptcy case listing the property as hers. The bankruptcy stay was lifted, which gave rise to our motion to reopen the case. The order lifting stay I would like to present to the court because it has some interesting language in it, Your Honor, which includes, it is further ordered that the bankruptcy court finding this filing of this petition was part of a scheme to delay, hinder, and defraud DMC REO LLC.
Here we go. Classic sovereign citizen opener. I don't consent to this court's jurisdiction. Judges hear this line almost daily from people trying to dodge accountability. Spoiler alert, it never works.
This is $1 million house in Ann Arbor that Ms. Whitlow purchased with a mortgage and less than a year later defaulted. The foreclosure went through, the sale occurred, the redemption period expired, and we came forward to evict. Since then, there have been multiple bankruptcies. Ms. Whitlow filed 2 different bankruptcy cases. A young man who apparently lives in Arizona filed a bankruptcy case and listed this property as his residence. Ms. Banks has filed a bankruptcy case and listed the property as her residence. It should also be noted that Ms. Banks was a bankruptcy preparer and has been forbidden from the bankruptcy court from preparing bankruptcies for anyone other than herself.
This case is a straight-up fraud, and it's just the way she thought it would all work tells you everything. I'm just assuming here, but I think she pretended to be the Whitlows, got a mortgage on a $1 million home, defaulted on it, and then turned around and tried to use bankruptcy to keep the house as if she had any legal claim. The only problem here, she's not even on the mortgage. I mean, that's like borrowing your neighbor's car, crashing it, and then filing insurance in their name. It just makes no sense here, and it's obviously fraud. Blows my mind is how she thought she could pull this off without leaving a paper trail. I mean, mortgages and bankruptcy filings leave records stacked a mile high, and once investigators start piecing it together, the fraud sticks out like neon lights. I mean, it's really not too hard to see. I mean, judges too, they don't just look at whether you said the magic words, they look at whether you had a legal right in the first place. And here, she literally has nothing. She just stacks lie on top of lie, thinking she could just overwhelm the system with nonsense paperwork. I mean, do you guys think she has any clue how bad this looks on paper? Or is she too far gone in the sovereign citizen mindset to even care? Because if she keeps pushing this, prison is not off the table.
I list all of these things to show that the scheme continues. And that's why we would like to reopen this case, because there is no stay in place. We would like to move forward with an immediate eviction, at most an 11-day vacate. And if for some reason that would not be amenable to the court, we would ask for an escrow order or a bond. On $1 million property, I think it would be reasonable that $10,000 a month rent would be reasonable.
Right. Sam,
Yes, ma'am?
what do you want to tell us?
Well, it's for 60 seconds, and then I wrote something up because I am nervous, quite nervous. But I, Doshia Banks, respectfully appear, specially and conditionally, for the sole purpose of protecting federally vested occupancy rights and opposing unlawful state action. I expressly do not consent to this court's jurisdiction and do not.
Well, then you are not a named party, so if you're not consenting to this court's jurisdiction, sit down. You can go, because you're not a named party. You are not a named party on this. You may have a lease with someone else, and then you can go challenge it. With who? Then you need to go against Miss Whitlow. Then you may need to go against Miss Whitlow. But if you're not consenting to the jurisdiction of this court, you might as well just sit down. You are not a named party. I do not have to hear from you.
Oh, I see. So I need to.
I don't know what you need to do, but
So let me respond.
to what? You're not consenting to the jurisdiction of this court. Why am I hearing from you?
Recant.
You're recanting what?
Stated.
Which part?
The part that that I stated that I'm not. Oh, I lost my spot. Not consenting to this court's jurisdiction, so I'm going to recant.
So you are consenting to this court's jurisdiction.
This is key. Bankruptcy court already called her filing a scheme to defraud. That's like starting the game already down 30 points. And yet, she's still in here arguing, as if she's got a shot. Would you double down in her shoes, or just walk away?
All right. Based upon the representation of counsel, I'm going to enter a motion to reopen this case. I'm going to issue a judgment in the plaintiff's favor for possession with a writ to issue 10 days of by signing. Should the matter be appealed, also contained in that judgment order, the appeal bond I would set at this time at a rental rate or a rate, and I have looked at the property which is involved in this matter, and it is significant property. I don't think the $10,000 quite does it based upon my calculation. So any appeal bond would be set at the amount of $15,000 per month that would need to be paid to maintain.
Thank you, Your Honor.
All right.
I will prepare that and present it to you this morning.
Thank you.
May I say something? Our lease payments was not that high at all. I'm not sure what her mortgage payments were. That was not our amount we paid.
Then I'll tell you what. If the Whitlows wish to come and object to my order of $15,000 as an appropriate, they may do so. I do not believe that you have standing to object to the court's order. Thank you.
Thank you.
Thank you. We'll await. Again. No.
Notice how the attorney carefully stacks all the fraudulent filings? This isn't just one mistake, it's a pattern. Courts look for patterns of abuse like this because it shows intent, not just confusion. And intent is what tips the scales toward fraud charges.